About to cite this research study case, which I think is a quite popular, well-researched case. It's two different people as Burton and Bastwick, but they were both involved with the church. This is back when they actually used to have church courts as well as the hundreds courts. Particularly in Scotland, they had church courts. And these guys were, you see, the church had certain jurisdiction as well for making orders and judgments, but this is to do with when there's a lot of religious arguments and disputes, which the Bill of Rights kind of like clears up quite a lot of religious disagreements. So these two guys, I've just kind of made 2 or 3 videos about it, and I'm trying to get onto another matter now. But they basically they get taken to this high court, ecclesiastical court, which is High Commissioner's Court, and they both petition the king, so they get their case put to the Star Chamber. You know, this right to petition the king. It's kind of like, the thing with that is, you know, the appeal system, apparently as soon as you had a charge brought against you, as soon as you had a charge raised, you know, before you even had your case heard or been convicted, you were meant to be able to petition the king and have a proper investigation by the Crown at a higher level, rather than actually even go to these other courts. Nowadays, the way they do it is you go to the magistrates' court, and then if you get convicted, then you appeal to the Crown Court, and then you appeal to the High Court, right? And then you could petition Parliament through the Appeal Act Jurisdiction Act. But they've always had this petitioning the king in the first place. Whether or not you're the one bringing the case to the king and not bringing the case to the local courts, or not, it appears that it seems like these people were the word appeal to the king, or that to this High Court Parliament, without having a hearing or trial in any of these other courts. I don't really know what happened to that, and how they got this whole appeal process. But whatever happened, you know, with this Constitutional Reform Act, but the Constitutional Reform Act still keeps this Privy Council jurisdiction, and also the Lord Chief Justice and Chancellor, who are in charge of certain judicial functions and courts anyway, can make representations and appeals to Parliament, which really, you can't. The Petitioners Committee is saying you can't petition about a legal case, but it seems to me that the Chief Justice can make put representations to the Parliament, right? To the Parliament. He can put representations and matters to the Parliament, right? So that means effectively you could, the thing when you're putting cases and appeals to courts, or you know, and so forth, the thing is that you can petition. You could get like 100,000 signatures, right, or whatever, to the Lord Chief Justice to put a matter which he has, which the courts have, which the judiciary has, to the Commons. But then what the Commons going to do with it? Well, this is the thing. This Henry Burton guy, both Henry Burton and Bastwick get convicted. Both of them appealed to the Star Chamber, but then at a later stage, both their wives end up getting petitions for their release. And this is when they get released by the Long Parliament, and the Long Parliament puts an end to all. They shut down that ecclesiastical court, actually, and eventually, I think that it starts again, but it eventually gets permanently shut down by the Bill of Rights. But they ended up combining the civil, and you see, they had the civil court, they had civil courts, and they had the religious courts, and then they had criminal courts. So besides like the criminal procedure rules and crime, common law, and then besides civil cases between Party A and Party B, you actually got religious courts. Like, you know, for your divorces and infidelities and, you know, owing money, certain payments to do with marriage and things like that. So there wasn't actually just criminal court, criminal procedures and then civil procedures between Party A and Party B. You actually had religious court. I remember you had those church courts as well. But the highest, you know, was for the church courts was meant to be this court of commissioners. But, you know, then you've got all this kind of like, you know, Henry VIII making himself head of the church, and I didn't know that got repealed. And then with Elizabeth I, then she gets put in charge of the church, but not the head of it. But anyway, so we've got people petitioning the House of Commons. This is probably why this is quite this is like a famous study. These are famous study cases. These are like well-known study cases. These, I can see why. We've got petitions to the Parliament for the release of people here after they've actually been convicted by the Star Chamber, by the King at the highest level. Now, like I said in the other video, I'm kind of going over and over and over the same things again now in these last 2 or 3 videos, and I want to get onto something else. But the reason why you can't do that now is because of that 1700 Act of Settlement, where it's like a conviction by Parliament can't be pardoned. Which means if you can appeal your way up to the top court, but if you get convicted by the highest court, then it can't be pardoned or appealed, right? But the thing with the right to petition is presuming it's on the presumption or the basis that you've got this right just to go straight up to the highest court, without having to do this kind of like leapfrogging, this kind of like magistrates court, appeal to the Crown Court, then appeal to the High Court, and then appeal, you know, to the now they're making you go to the Supreme Court, right? But what I want to draw attention to is this point, and that's before I go on to my next thing that I want to go on to, right? Look, the Angela Ditchfield case, right? Riddle me this, right? Angela Ditchfield, right? Criminal damage charge, right? Of which she is actually acquitted, right? Not guilty. So then the Crown Prosecution Service come in and say, oh, like, we're not happy with that, which they don't do very often. If you win, you win, right? But they go after her. Now, I don't know if the whole thing's set up, because I really think they were trying to do some legal manoeuvres to try and put the fire out on all of the protesters, you know, painting everywhere. It's almost like it was rigged and set up. But, so, if Angela Ditchfield had been convicted by the magistrates' court at wherever it was, Cambridge or Bury St Edmunds or wherever it was, somewhere around there, right? If Angela Ditchfield had been convicted at her trial, right, and then if she'd have wanted to appeal it according to procedure, she would have appealed it to the Crown Court. Am I right or am I wrong? And then she would have been before a jury trial at the Crown Court. Now, Extinction Rebellion have been getting 50% acquittal rates at Crown Courts. I got asked, in my case, I got asked by the judge, Fudge. She asked me and if I wanted to, have it dealt with by the Magistrates Court or Crown Court. Apparently I could have nominated the Crown Court. I got asked. Now, why didn't I say, well, I want it dealt with by the King, by the, I want it dealt with by the Privy Council, but I'm sorry, Your Honour, but the matter's already been dealt with, House of Commons, But the thing is that also, she asked me whether I wanted to, you see, Crown Court's indictment only, really, meant to be for indictments, not summary offences. The thing is that all summary offences are meant to be prosecuted within, whatever it is, like a month or 30 days or whatever it is, right? And it is only Crown Court ones. Now, the thing is, the police were umming and ahhing about charging me for ages, right? Now, when it ended up going to the Magistrates Court, really, they were out of time for that. So why were they asking me whether I wanted it a summary charge or whether I wanted to go to Crown Court? Because having it in the Magistrates Court, really, for a charge on summary is you got a time restriction. It was a strange offence where it can even be dealt with either or, whether it can be dealt with either summarily or indictment. Now, the thing is that at that point, I already had the matter's already not to be dealt with by that court anyway. Now, the thing is, right, why didn't the Crown Prosecution Service bring the charges against me in the High Court or Supreme Court anyway in the first place if I'm claiming that I've already got House of Commons casework that I'd already started? So, with Angela Ditchfield, right, why I want to know is this, right? Why aren't the Crown Prosecution Service, when they appeal, Angela Ditchfield was acquitted, so it's the prosecutor who's appealing against the acquittal. So why didn't they go to the Crown Court for that? Why didn't the Crown Prosecution Service go to the Crown Court? Right? Why is it the High Court that they go to? That's the main point. For Angela Ditchfield, why do they go to the High Court? Can they not go to a Crown Court? Why is it High Court? And this is the thing, right? Now, with my case, I don't think that it should have been the Magistrates Court in the first place. But the thing is, they go to the High Court. They go to the High Court to have something changed or overturned from a Magistrates Court. So you've got Magistrates Court, then you've got an order made in a Magistrates Court, right? Now, but then you've got the Crown Prosecution Service take that matter, that case, to the High Court from the Magistrates Court without going to a Crown Court, as far as I can ascertain. If I've read the document right, I've got the casework file somewhere. I'm quite sure it wasn't in the Crown Court. I'm sure it was a Magistrates Court. Now, that means that, right, a matter can be taken from a Magistrates Court to the High Court, right? Now, is there anything similar to that that's happening? Yes, I got convicted by the Magistrates Court. And I am complaining against the judge. I'm bringing a case against the judge, or I've got a case against the judge. And that case is brought to the High Court, right? Not the Crown Court, to the High Court, right? And the thing is that that's the same jurisdiction change as Angela Ditchfield, right? I'm quite certain, if you check, and maybe I'm wrong on this, but I'm quite certain, according to her case files, it was Magistrates Court, acquittal, and then the CPS went to get her convicted in the High Court, but not in the Crown Court. If I read it right, I don't think Angela Ditchfield was acquitted in the Crown Court. I think it was the Magistrates Court, I'm sure. I can read it again. So that means you can get a High Court to make or change orders from a Magistrates Court without having the Crown Court act in between. So surely if you can go from Magistrates Court to High Court, you could go from a Magistrates Court to the Supreme Court or whatever it is, Privy Council or whatever you want. Whether it's, the thing with the House of Commons is they refer things to courts anyway, but usually if it's quite a serious matter like public inquiries and matters to do with public inquiries, it's the High Court because they can deal with civil and criminal matters. Now, this is where I am now with my case